bear and his deer.
You're lucky.
Welcome back, folks. This is House Corrections. No, it's not House Corrections.
No.
This is Joint Justice Oversight, just back to my old role. This is Joint Legislative Justice Oversight. Sorry, corrections. This is November 21st, Thursday. We're back on our afternoon meeting. We're shifting gears a little bit. We're going to be talking about pretrial diversion. This is all part of our, I'm going to be pretty broad here. It's part of our community justice center establishment work structure. Last legislative session, there was a lot of work done at House Judiciary as well as my committee, dealing with the flow of dollars that go to our community justice centers. And the community justice centers do a lot of work for folks who are pretrial in diversion, as well as restorative justice, and work a lot with folks who re-enter from an incarcerated setting. There's a whole umbrella of work that is done. And there's a lot of different funding streams that go into our community justice centers. There's funding streams from DOC, and there's funding streams that come in from the Attorney General's office, and there's some a little bit from DCA. And the legislation was really trying to match up those funding streams with the actual delivery of services to the respective clientele. And so Martin's committee, House Judiciary, did a lot of work on this. They worked a lot more on the pretrial diversion piece. The House Corrections and Institutions Committee worked more on the corrections piece for folks who have been incarcerated and under the custody of the Commissioner of Corrections. So we're trying to clarify the funding streams for that, and this is all a work in progress. And so we just want to do an update in terms of where we are with the Attorney General's office in particular with the pretrial diversion piece of this. So that's kind of like the big umbrella of our community justice centers and the funding streams and what we attempted to do. So Tim, I'm going to turn it over to you to begin the update. And we also have some folks here from the Attorney General's office to talk about the pretrial services.
Yes, and definitely Mr. Chair on screen there. If there's anything you want me to, focus on, all the work that you did, just let me know. And some of this will make more sense probably after Willa goes too. But thanks for letting me go first. I appreciate it. So yeah, last year, H645, was passed, and it really, I think, a lot of work in the House Judiciary. And I think it turned out to kind of be a good balance of different things. I first want to say, kind of outside of the state's attorneys, that the Department of State's Attorneys and Sheriffs, should have done that for the record, Tim Leaders-Dumont, Department of State Attorneys and Sheriffs. The funding needs to be sorted out because we do need this option. Like we need to be able to send cases as fluidly as possible to as many different entities as possible. And there needs to be the resources in the community to send those cases. Once a case is actually charged very consistently now, and Will and I were talking over the last couple of weeks, like about 20% of all misdemeanors are going to post-charge diversion after a filing. So what we're talking about is before the charge, how we're able to send things different places in the community. And there are different names for those things, which will maybe change over time, which will get into, and Rachel will get into as well. So from our perspective, last year, there was a couple kind of big requirements with maybe a 2025 settle-in date. One was that the state's attorneys publish what their policies were with respect to pre-charge referrals. So before the filing of a charge, sending a case to referral. So at this point, 7 state's attorneys, so half of the state's attorneys have sent those to me, worked with me, and we published those on our website. There is a pre-existing policy from Washington that is not the current policy, but it's posted on our website because it's helpful. It was the first published policy on this issue by now Judge Tebow when he was the state's attorney. And some of the other ones, they have some similarities, they have some differences. But I really think if you go to our website, you go to legislative reports, pre-charge policies, you'll see all of those listed there. So we're 50% compliant a year out, or essentially less than a year out. But so we're kind of working away on those. All the state's attorneys will gather in December. I will talk with them again at that point about submitting those policies. But just so you're aware, well, we've got you here, Rutland County, Orange County, Windham County, Caledonia County, Chittenden County, Essex County, Addison County, and Bennington County have all published policies. Orleans is probably going to send me theirs today. I believe they now have a unified office up in Orleans, meaning their prior DOC funded and maybe DCF funded CJC is now combined with their post-charge office, which I think for that county is really good. Our state's attorney up there can now send the whole universe of restorative justice things to one location. So that policy, she was sort of waiting for that to settle out because it was a moving target, and she'll send that off to me, and then we'll be 50, getting past the 50% marker in terms of compliance before 2025 settles in. So we're moving along with those. Is there any questions on the policies before I move to, I think, probably the second question that the chair may have? And after you look at them, if you have any questions on them, please let me know. Yeah. And the purpose of those, moving into kind of, I think, the second point, is to kind of let the is to let the citizens of that county know how that state's attorney may address something pre-charge. Last year, there was a distinction put in the statute to separate out something with probable cause and something prior to the finding of probable cause, or maybe just before the ripening of probable cause. And so those two categories are technically pre-charge, which is actually a finding of probable cause. That's just sent to a referral location, or a community referral, which is without probable cause, but still sent to a location, referred to a location. There's a lot of different perspectives from the state's attorneys about that universe. Some of them really want probable cause in every single circumstance. Many other state's attorneys like the fluidity of kind of the community referral. Don't go back to your agency and write up the probable cause affidavit, send it over to Rachel's office. Just go down the street and see Rachel before we write up the affidavit, something like that. So there's a lot of different perspectives on that. And I think it's good to keep it fluid. And I think the bill last year tries to balance that. One of the important policies that I think is embedded in the legislative intent from last year and is really supported by the state's attorneys was that the discretion of the state's attorney to refer or not refer is really codified. That was really important to us. And we want to thank everyone that was involved in that process. The second piece is about the documents, the records, the emails that get generated when we're doing a referral prior to filing the charge. So you may wonder, what does that sort of look like? As someone that used to do pre-charge referrals here in Washington County, what that looks like is occasionally not an affidavit, but an email from a law enforcement officer or even a phone call where they're talking to you about a potential crime. And in that process, you're creating records. In state government, those records kind of take on some sanctity because then there's records policies that apply to all state employees. But it could be an email, it could be a draft affidavit, it could be a form that says case review. But there's a whole menu of kind of documents, mostly informally, get generated in this environment. And then let's say we want to do the referral. A lot of offices, and there's examples on our website, have a referral form. I want to send this to the Burlington Community Justice Center. I want to send this to the Unified Orleans County Diversion Office, whatever the case may be. And here's the affidavit that the officer drafted, because in this case, there was probable cause. And you send it off, usually by email, or drop it off in person, or by mail to these locations. So you've now created a record. From our perspective, the court's not involved at all. We're sending something, we're diverting it, we're deflecting it, but we're still creating a governmental record. And if law enforcement was involved, they've created a Valcor record in their database. So now there's kind of two universes of records that are getting created. And the question is, what's the value of those? From our perspective, there is immeasurable value and legal significance even at that point. Brady Giglio, I'm not going to dig into it here, but it's basically an incredibly important requirement that the entire governmental arm must submit all relevant information relating to an individual who is involved in the criminal justice system. So let's say someone is later charged all of that information, their contact with law enforcement is very, very relevant to what happens to them later in maybe a subsequent case. Also, let's say a person who's a victim or witness has information, has had come into contact with law enforcement in the past. All of that's very relevant to future interactions with the criminal justice system. And we have a duty under the professional rules of conduct and the rules of criminal procedure and the United States Constitution to turn over all relevant information to the defense, and then we can litigate whether or not it's relevant at a trial. But a perfect example would be, and I'm going to use Attorney Novogrowski as an example, he and I get into a fight outside on the lawn, goes pre-charge here in Montpelier, and then later down the line, I actually get charged for simple assault on the lawn again, but this time with another attorney. My prior interaction in that situation would be very relevant to me. Let's say I went to pre-charge and I was successful and the case was never filed, right? Court never got involved. When I'm later sentenced for that simple assault, I want to turn to the state's attorney and say, remember when I did really well with pre-charge and my restorative justice path? That's relevant. To delete that record would be, in my opinion, a violation of my due process. You need to keep those records so that you can turn them over when they become relevant. And what we built into the bill last year was a very eloquent solution. Non-public database, our state's attorney database, is where we could keep those types of forms, emails, informal documents, so that we're not deleting important legal information for defendants and victims. So that's reflective of current practice. Prior to the passing of this bill, that's what we were doing, and you codified that last year in the bill. We would ask that that continue to be the practice that you endorse. And last year there was, in working with Chair Lalonde and his committee, I would say an inadvertent miscue that was later fixed, and we really appreciated it, where law enforcement could keep the documents, but we couldn't. And that sets up a whole bunch of issues as well, where police and prosecutors should not be on unequal footing. And you fixed that in the bill last year and was really important. None of the policies that you'll see on our website are going to encourage the deletion of pre-charge records, right? If it did encourage the deletion of pre-charge records, you're going to see less pre-charge referrals because it's another mandate on deletion, and it's a non-court ordered mandate. Right now, the only deletion of court-related records prior to the dispositional periods that are in our records policies is when a judge sends you a really important piece of paper that says seal or expunge. Non-court ordered sealing, expunging, deletion of records makes me very nervous, because we need to have a level of transparency for our victims, our defendants, and our witnesses as to our maintenance of records. I helped draft with Evan Meenan in our department very extensive records policy, which I will not bore you with today, but it's incredibly long, and it addresses how we deal with things like what I would call case reviews and investigations. They're addressed in our records policy that the Secretary of State's office has already approved. We don't want to meddle with that, in addition to not violating the Constitution. So at this point, I would say our record retention policies with respect to pre-charge practice related material is that we generally keep them in a non-public database and use them for criminal justice purposes, which is a defined term in statute, which is basically the adjudication, investigation, et cetera, with respect to individuals who are charged. So we use it only for that very limited purpose, which is essentially, not to confuse the matter, but essentially how sealed documents are used. But we're not talking about sealing and expungement, because that's only for filed cases. So hopefully that was a helpful overview of what I understood that the chair was interested in, and happy to answer any questions. And I did post the Rutland, or Megan posted the Rutland policy online. You'll notice there's a reference to basically retention of records as allowed by law, which is essentially retention of records as allowed by the law you passed last year.
So we do have a question here.
Yes.
Nada, it's online.
Thank you. Hey, Tim, it's good to see you. Could you just refresh my memory if somebody fails pretrial diversion, those records remain in place, right?
It's a great question. I should have mentioned what I was talking about was the successful completion of a pre-charge referral. If someone's not successful, then the way it sort of work depending on the situation. Rachel can talk more about an unsuccessful referral and how that works in practice in Chittenden, which has been doing this for a long time. But basically, it could get returned back to a law enforcement officer who can then prepare a more formal affidavit, collect more evidence, and then send it to the state's attorney for a charge. What I was talking about was successful completion of pre-charge. Yep.
Yeah, and what I'm trying to get at is, you know, if it's unsuccessful, there's, still a pathway for something to happen, to the defendant. But if it's successful, then it can't be used by them in the future. So it just kind of seems like, yeah, that's just one point I wanted to raise. So thank you.
Yeah, absolutely.
Any other questions, comments? That was quick. Thank you, Tim. I know you have a commitment elsewhere, so. Willa, you want to come up? Bring anyone with you that you want?
I usually use Connor Case.
Shall I start?
Or just identify yourself for the record.
My name is Willa Farrell. I work in the Attorney General's office with court diversion and pretrial service programs around the state. And thank you for the opportunity to be here today and talk a little bit about Act 180 and pre-charge diversion. I thought today I would speak a bit about our office's role, talk about the benefits of pre-charge diversion, some of which you've already heard Tim address, and the needs that we see going forward. So I just want to say that we're actually excited to be doing this work in the Attorney General's office. We have, I think, many decade experience of working with community partners and have a strong post-charge court diversion and pretrial services array of services throughout the state. And we want to work towards modeling that pre-charge and creating a unified, effective, accessible set of services that are expanded throughout the state. The work that comes now as of Act 180 under the AGO's umbrella is all pre-adjudication and within the sort of early stages of the sequential intercept model, which I think some of you are familiar with from many meetings and discussions. The benefits of some of the sort of technical aspects of the act which you passed, which I think are worth noting, is that you laid out the rights of victims and participants, formalizing those in law, setting parameters for statewide programming, and requiring data reporting in a more robust manner. We see the formalizations of set of services as valuable and really see our role as supporting the growth in communities around the state. Certainly, as I think many of you know, there's a lot of pre-charge programming in Chittenden, but there also exists in Caledonia, Washington, other counties, but not in all. And we're looking forward to helping really roll that out and develop that throughout the state.
So, Willa, who are you working with to roll that out in the other counties?
Well, with whom am I working now? Currently, the efforts that I've been focused on are in areas where there's more than one pre and post charge existing provider. The act directed us to work on streamlining the administration and delivery of services in counties where to date there has been no pre-charge diversion. The conversations I've had both with state's attorneys and with program directors is that there's really growing interest. I think this legislation has generated true interest among state's attorneys to use pre-charge diversion. And really if I could touch on the benefits, which I think are drawing state's attorneys' attention. First thing that I hear when I go around and talk to people about pre-charge diversion is that it's a quick response. It's very fast. People are directed to contact the provider within a few days. There's no waiting through the court process. So the timeliness is really valuable, both for the person who committed the crime. It's the immediacy of response is more meaningful. Also hugely beneficial for victims because they are getting support and information, connection to resources quickly. Everything that we all want whenever we're using a service.
I also asked for clarity. Who would be those providers? Just so folks were not familiar with this whole system. Who are those providers?
So around the state, there are what Representative Abbott has referred to as community justice centers. So in many counties, you'll have an organization that has that phrase in their organizational name. In Chittenden County, there are 4 of them. In Washington County, there are 2 of them, but there's also a court diversion, an agency that has court diversion in its name. In many counties, Lamoille, Bennington, Orleans, Orange, there's one organization that may call itself a community justice center, or it may not. In Orleans County, it's actually under the CAP agency, Northeast Community Action. So it's an array of service providers. They are all community-based. In a few occasions, Chittenden County and here in Montpelier, they are housed within a municipality. Everywhere else, it's a nonprofit organization. I think the other piece, and Tim alluded to this around the benefits of pre-charge, is that really saves the workload of prosecutors in the court system. In many of the policies established by state's attorneys, they are not reviewing the paperwork, they are directing law enforcement. These are the situations in which I, as the state's attorney, am comfortable with a pre-charge referral. So there's no involvement of a prosecutor or a judge. A lot less time, a lot less required of the court system. And as you can imagine, it is less costly. And there are really significant costs that have been avoided for decades now by having a robust pre-charge program in certain parts of the state. And that's part of what we see going forward, is developing that capacity throughout the state to bring both the benefits to the individuals who are being involved in whatever happened, but also to the system, to prosecutors, to the courts, and statewide. But I think, as you all know, we're looking into a coming fiscal year where we will need funding in order to support this work. We need funding in order to provide grants to community partners, as well as a position in our office to actually provide the support and the leadership to programs around the state, so that we can be consistent with all the requirements that are laid out in Act 180 about data collection, program standards, and manual and the like. Our office, the Attorney General's office, submitted a request to the governor. Obviously, we won't know until January whether that is included in the governor's budget. And we will be coming to the legislature to explain our request and to ask for funding for the services for community partners to do the work, as well as a position for our office. I also, in the conversations I've been having, have here a refrain, which is very understandable and I appreciate, about the challenge of the lack of predictability of funding. It is very difficult for community organizations, for municipalities to support this work when they do not know from one year to the next what funding will be. Certainly with all state funding, there is uncertainty, but within a dedicated line item within the Attorney General's office, I think there's more clarity and assurance for providers. So I would just like to quickly recap that, our office is ready. We've been doing preliminary work. We look forward to the transition and supporting, working with community organizations and state's attorneys. And we're really focused on having an effective system, accessible, efficient. And we look forward to working with the legislature in the coming year to make sure that there's the funding for both the providers and the resources that our office needs.
So I just want some clarity. When you recommended a line item within your budget,
Yes.
that would be for the pretrial diversion.
For pre-charge diversion.
Pre-charge. Because that's one of the things we've been working on for a few years is really clean up the funding streams because they were getting so intertwined.
Yes.
And now, because part of it comes from DOC, part from DCF, and part from HL.
I think what the legislature did last year, what you did last year was to bring clarity to pre-adjudication work falling under the Attorney General's office umbrella, and then post-adjudication for adults within corrections.
It's just a request. Willa, could you just make sure to include a copy of your statement or your testimony or summary of your testimony? So
Certainly.
have that in writing, that would be great.
Certainly be happy to.
So how much, and maybe you can't answer this, were there dollars coming from DOC that was going at all towards any pre-adjudication work?
My understanding is the Department of Corrections was grants included support for pre-charge, what were called either pre-charge or direct referrals, but the amount I do not know.
Just thinking. Good.
Thank you.
Great, thank
Thank you for
you.
your work.
Yes. Thank you. So Rachel.
Yeah.
I'm also, I don't know if you're gonna touch on this at all or not, but I know one part of the legislation in this legislation that was put in, came out of my committee to really work with the community justice centers to figure out sort of their, I'm gonna say it loosely, their structure. Because every time we started really working with this, it's each center is sort of their own entity and there isn't one voice at all. They all do important work within our within our justice system as a whole and for the communities, but some of them have a different focus, are structured a little different. So every time we try to look at what are the services provided, what do they do, where's the funding stream coming from, it goes from justice center to justice center. So one of the things we did in the legislation is to really have the community justice centers kind of come together and figure out if they could figure out a better structure to be maybe more unified or more where we could understand their roles and how they all work together or don't work together. So that was another part of this piece of legislation too.
Yeah, I'll just start by introducing myself. For the record, my name is Rachel Jolly. I lead the Burlington Community Justice Center for the City of Burlington, which is part of the Community and Economic Development Office, or CEDO. So to that point, Representative Edmonds, I think that's where even terminology does get confusing. That Willa was speaking to, even the term Community Justice Center, some would take automatically as meaning that that agency gets DOC funding. Some just think of it as, oh, you offer restorative programming. So it has gotten confusing, even though it's accurate to say CJCs, because again, literally some of us have it in our titles, as we do. But what I have found more useful is just talking about the 22 organizations that somehow get state funding to do restorative justice, or use restorative practices within the criminal legal system. There's all kinds of service providers who might use restorative justice and those who are not, even informal organizations. And then within those, there's definitely overlap. And we've tried last year, I think that was part of the education, is to show where the overlap is in terms of services and where it's not. I think that the structures of this DOC funded programs has been a little more loose in that we don't have a nonprofit. We used to, the Community Justice Network of Vermont, to help organize and speak with that one voice that we can understand legislators are looking for. Whereas with the AGO funded programs, we do have VACDAP, or the Vermont Association of Court Diversion Programs, that is very, very collaborative and does work very hard to speak with that unified voice. It's headed by Willa, but also with a very collaborative formal structure that involves the providers themselves. So all that to say is, I think Act 180 is getting us closer to a more unified structure with clarity, at least, around the services that are offered in a consistent way statewide. I don't want to deny the history of these 22 organizations that do have different origin stories and services offered, but I think there is something beneficial of the clarity that comes with the AGO's court diversion and pretrial services programs that could offer pre-charge as part of one of those forms of court diversion that has some uniformity and stability there. So to back up just from, I was asked to speak a little bit about the Burlington Community Justice Center's use of pre-charge. The BCJC has been in existence since 1998, and we've been receiving pre-charge referrals directly from police since at least 2004. We have operated under a memorandum of understanding with the Burlington Police Department and have always valued the relationship and this type of referral for its expediency, which we've heard about today, which benefits both the victim and the responsible party, its method of keeping folks out of the system and further upstream when possible, and its high success rate. So pre-charge referrals work best when the person responsible for the crime is a first-time offender, does not have substantial mental health or substantial substance use issues that are interfering with their day-to-day living, and is willing to take responsibility up front for their behavior. When those conditions are not present, we have other programs that might be more appropriate. But I just want to, again, clarify that pre-charge is for a kind of a certain type of crime and incident, and it's part of a continuum, and it's not right for everybody. But when it is right, it's been working very well for 20 years. The 4 community justice centers that are in Chittenden County collectively receive an average of about 460 cases per year. And we generally see a success rate of between 70 and 80%. Cases can be returned for a lack of engagement or an inability to take responsibility, but it is worth saying that part of the learning that we have, having worked for so long with our police departments, is one point of frustration was that if for whatever reason they were returned or they didn't successfully complete, the work was back on the officer to track down that responsible party. So one thing that has changed for the 4 CJCs in Chittenden County is that at the point of citation, we do issue a court date. There is a court date issued. It varies for how long that might be out, 4 to 6 months generally for the various CJCs, so that if and when that person doesn't successfully engage for whatever reason, that court date is already out there. So our general guidance is to keep a case open from 60 to 90 days, but depending on specifics, it can be shorter or longer. But again, that underscores the expediency part of the benefit of this program, so that we could get cases within days of the incident and have them closed within 3 to 4 months is sometimes a far cry from anything that goes post adjudication or even post-charge diversion. So the 4 community justice centers, town managers, police chiefs, and Willa Farrell have been meeting regularly for the last several months to plan and coordinate for the implications of Act 180. But I will say one of the hardest parts so far is the uncertainty around funding. As you can imagine, everyone's hope is to have no disruption in services. For a county like Chittenden County that has been offering pre-charge for so many years now, and that work has been funded through the Department of Corrections, now we have this layer of uncertainty given that Act 180 is passed to move it to AGO, but simultaneously there's been a recent release of, as you might know, a request for proposals from the Department of Corrections that is changing its historic 17 allocations down to 13 and using a regional model. So the more advanced funding notice of funding allocations, the easier it will be for us all to plan. We have been discussing a variety of scenarios in Chittenden County for governance, as well as talking through what a centralized intake model could look like. And though no decisions have been reached yet, I'm personally eager for the consistency and the clarity and the increased oversight that management from the AGO will offer. So again, as I have been and testified to the point last year, Act 180, I think, is moving in the right direction. I am very much in favor of this more consistent and equitable program that offers consistency, and the funding is a crucial part, as you can imagine. So knowing what we could depend on, or at least even a ballpark estimate, as we navigate this shift from DOC to AGO, it would be very, very helpful. So I'm open.
So do you think this uncertainty with the funding is just a result of the whole transition of the whole structure?
I mean, some would say it's been kind of coming for a while now, that there's in any state funded, 22 organizations that rely primarily on state funding. State fund is often looking for efficiencies and more streamlining. Burlington CJC has been an advocate for that kind of streamlining, but there's been differences of opinion. Some people's original vision would see more CJCs in every town to have its own local control. But I think that this is the funding, the passage of Act 180, yet the fact that it didn't include funding and the simultaneous release of the RFP just creates, I guess that's the transition you might be talking about. Then yes, that's where the uncertainty lies right now.
So I think, and Martin, I don't know if I'm speaking out of turn here, but I think the intent was not to, in the end, not have less funding going out the door. It was to clarify the source of those funds to the appropriate services are being provided with those dollars. That was the real impetus. It wasn't to cut any of it.
I trusted that seemed like the clear intention from the beginning.
Yeah. At least that's the testimony of my committee. Martin?
Yeah, so that certainly was is the intent.
Yeah.
And there was a certain amount of funding certainly coming from DOC that I think that they have, the DOC has since repurposed for other very important programs, such as having restorative justice programming in the facilities, which I think I certainly support, but that means that we have to make up that other funding that they've taken away regarding pre-charge. But just I want to make a couple quick points here as well, that one of our biggest push this past year was dealing with court processing of cases and the court backlog. And it was really, we looked at a 2-year plan as far as the funding for that work, with probably a 4-year goal of trying to get on top of really the processing timing of cases. For our second year, looking at the second year of that effort, probably the number one lever that we have to pull funding wise is in fact getting the pre-charge diversion up and running. And that's really where a focus will be for that second year. From what I understand, for instance, the courts don't need or are not going to be requesting additional funding at this point. And also, we will talk to the prosecutors. They definitely have some additional needs. Defenders do as well. But the very important need is going to be this pre-charge program. And I'll point out that at the last meeting, the DOC presented a chart, and I don't have it in front of me, but a chart that showed how many cases are solved in Chittenden County, how many cases were solved in Chittenden County in 2023. And that was over 400 cases that were successful through the restorative justice process that otherwise would be going to prosecutors in the courts. And that we need to avoid. We need to avoid having an additional several hundred cases going to the courts, giving the backlog and giving what we're trying to do. And I can't emphasize that enough, even though that's just part of the story. I mean, it's more important for victims. It's more important for timing of a consequence, et cetera. But I just want you to know that that's going to be a focus, at least in the House Judiciary Committee, as far as where we think public safety additional funding or continued funding really should go. Just wanted to make that clear.
Thank you, Martin. Other thoughts, questions?
I just have a quick question. So this is my lack of knowledge or understanding about this. And I noticed in the Rutland application, there's a place for the harmed person's name and information. Do they have input into whether or not this happens at a want to make sure I'm using the right pre-charge, yeah, a pre-charge diversion happens or not?
That's an interesting question in that in our MOU with Burlington Police, we did just add that in our most recently revised that if the victims essentially would have to give permission for it. We have not historically had that either or kind of scenario of if they are against it, then it doesn't go to pre-charge. But one of our first outreach is to the victim and to see how and if they want to be included. Sometimes they do have like a strong stance of like, no, I want punishment in this case. Again, that's like hasn't been our practice to say, well, then okay, but we're sending it to the state's attorney. But ultimately, it would be the state's attorney. It's not the victim who gets to decide if that's being charged or not.
Thanks, I appreciate that. I'm just, I'm trying to think about, from our conversation earlier this morning about victim notification and participation in a process where, an individual has been harmed and, trying to figure out their role or, maybe potentially lack thereof in these processes. And the other thing that this has always been a bugaboo for me since my first year on Alice's committee. Is, and that's this like regional sense of justice. And, when you just said, well, our MOU with the Burlington Police Department, and then, you see the Rutland MOU, and then you see the, and I really feel like this isn't you, but I really feel like the Department of State's attorneys and sheriffs should be providing more consistency among our state
I mean,
counties.
yes, to me-
It drives me bananas.
Well, to me, that's exactly part of the origin of this bill, H 645 last year was to have a little more geographic equity. The fact that you could have the exact same crime happening in one town, and then if you cross the county line, you'd get a totally different response, was part of the impetus. And I think, again, with the AGO's oversight and management, that is what we would be heading for. Rather than these MOUs with particular police departments, it would be more of a statewide guidance and policies that instructed all, ultimately, we still have the state's attorney's policies by the county. So we're inching our way towards more geographic justice. But I think this Act 180 gets us further along than we are. And I will just say, in terms of your earliest point, or your earlier point, that around victim voice, that is, I of course have a bias of believing that that's one of the strongest parts of restorative practices, in that they have so much more of a voice than they do in the mainstream system. So if they do want a large role or a large voice at the table and have very specific asks, that's our job as providers to make sure that comes across loud and clear, even if they're not physically present.
Thank you.
Ben, you had your hand up?
Yeah, and I just wanted to address those 2 points as well, in addition to what everything that Rachel said. So for the record, Ben Grosky, the Office of Legislative Counsel. But in the legislation, there are 2 provisions one provision that specifically addresses victims' rights. A manual needs to be created by the Attorney General's office that outlines the victims. It's their duty to give this to the providers, and the providers would use this to inform victims of their rights, enroll in both pre and post-charge diversion, including that such available, including providing that in the writing terms that they have it for reference. The timely notification to victims of a pre or post-charge diversion referral, an invitation to the victims to engage in the restorative process, how to share information with the victim concerning the conditions of the restorative justice agreement that are related to the victim and any progress made on those conditions, because there is a little bit of a privacy issue there. And then best practices for all parties to engage, confidentiality expectations. And so that is considered in the legislation. And then to the point about geographic equity, that's actually how this bill started, is that the Attorney General's office was initially mandated to create the policy that you now see the individual state's attorneys posting, was supposed to adopt it for them, and they needed to adhere to it. However, there was I would say, a robust conversation about the constitutionality of the Attorney General mandating that other constitutionally elected officers to do that and to take away their discretion. So that was a big topic of conversation.
Yeah, I understand that, and that's sort of the push and pull that you have when you have, elected officials at the county level. And one of the things that I wondered though is there's nothing that prevents a statewide office, whether it's the AG's office or the Department of State's attorneys and sheriffs, of like we have with the Agency of Education, draft policies to, that can be adopted or modified or whatever at the local level. Is there? That's a question.
It evolved from a mandated policy to the adoption of a model policy to a requirement that the state's attorneys adopt a policy that met certain requirements. So that was
Each state's attorney.
Yes.
Yeah.
So it was considered at one point.
That's like nothing.
But again, that it was that sort of constitutional question about you have these 14 individually elected officials that are mandated by the Constitution to have prosecutorial discretion. And you have this push and pull of another entity telling them what to do.
I get that. And then I asked my question, like, why do we have a Department of State's attorneys and sheriffs?
All the state's attorneys are independent.
Right. That, I mean, I think it's a
So we
question
don't
worth
need that.
asking. It's
That's
a
what
question
we
worth
don't need it,
asking, I
right?
think.
No.
I mean, I know
I
they do I know they do other things, I'm just saying, I know they do other things.
Look at Martin.
I know Martin's freaking out.
So-
Aren't you glad you're not here?
No, I can address that very briefly, that the Department of State's
it's
attorneys,
okay.
they do act as a coordinating role, and they are helping with each of these policies. So to get some consistency there, and this is certainly a first step. And I hope to get to a statewide policy once these 14 laboratories of state democracy come up with what they have, and we will push the best one at some point, I promise.
This just happens to be the topic du jour about this particular pet peeve of mine.
So it's my pet peeve too. I agree with you.
It's our pet peeve too. It's our pet peeve in the House Judiciary, believe me.
All here together, we're all pet peeving.
Welcome to the world, Nader.
I guess.
Great, thanks.
I want to stick with that for a minute, and then I have another question, comment kind of thing. And related to you or not, so it's going to be more general, the second one, but no separation of powers issue, the two elected different ones, constitutional officers and so on. Nevertheless, the legislature does make policy for each one of those constitutional officers. So theoretically, we could direct following a specific policy, regardless of what it is.
I think that there are approaches that the legislature could use to either incentivize or require compliance. I would also be remiss to say that I think such strategies might be met with litigation. So, such strategies might be met with litigation.
Oh, well, I understand that. I get it. But and that goes to my second question, which is probably for the room, but we've been hearing a lot about how the goal of this is to try to bring the money together and to know who's spending what and who's getting what and how it's being distributed. It would be helpful to see how it happens today. I'd like to see that kind of.
The flow chart?
The flow chart, and then.
I think we had that last year.
Last year.
Yes.
Last year, we don't have it this year, but then
Yeah,
the other
that's changed.
part of that is, once you have that and once you understand that your goal is some common policies and procedures that really, I think for many reasons are important, equity being one. Once you have that, then you can incentivize. I was going to go with that word and I heard you say it, but you can incentivize the work of organizations, whether they're state's attorneys or criminal justice centers or community justice centers or others. So it's.
Yeah, I just wanted to point you to Act 40's, is it Act 40? The Act 40 report that the Crime Research Group just put out. There's an interactive website that shows the data of all the allocations from the three main funders. It has, yeah. So I'm happy to send that.
No, I would love to see it. Maybe we could just have Megan post it up for us.
Yeah.
That'd be great.
Yeah.
Thank you.
Send that on.
Just send it to Megan, she'll put it on for us. Then we'll forget to look at it.
Now, so it sounds like there could be a lot of fun in your committees, your judiciary committees.
Representative Luan thinks of it.
Yeah, I'll help you out, Martin.
The Nodder is very stoic.
If anyone wants to help me out, that would be great too. Looking forward to it.
If the committee would like, I mean, I don't have, center lines, were you talking about actual amounts that were distributed or
Yeah.
just services provided by each?
Both, I mean,
I have the services.
not the service.
I don't have the amounts.
Well, it'd be helpful to know how the money flows, I think. And I don't know, that's gotta be somewhere in everybody's budget, somewhere along the line. Is there, in a good sort of, I know, well, it seems to be one of the big issues, huh?
That's why I don't want to be.
The report does include that.
That's why I'm on appropriation.
Yeah, I don't want to get near reports.
I
We'll
can
figure
do
it
some
out.
digging if you want, but
No, I'd wait till the
No,
session.
don't do anything that
No,
the chair is not thinking was important.
not yet. There may be more folks when you're into
Yes,
approach
that's it.
doing markup.
We have our other witnesses?
Yes, not for this.
No, but I mean,
Raise the age.
raise the age, yeah.
Are they online?
Yeah.
We can let them in.
I'm gonna have to leave just before 2:30. I know.
And we're meeting again on the 17th of December.
Yes, sir.
This is the data we are, like, see basically, pretty statements, I can be honest.
Why don't you email it to Megan?
Yeah, send it to Megan. Everybody should see it.
Everybody send everything to Megan.
Megan. sent it.
So, we just want an update on how we're progressing here for Raise the Age. I know, Martin, remind me again, April is the date that Raise the Age kicks in
Yeah,
again.
Yeah, on the unfortunate date of April 1st, if I'm not mistaken,
Oh,
so.
good, April Fools.
Right.
And the age would go to what, 20?
19,
19. Okay, so this is an update. I know that you may have a report, you may not. I forgot how often those reports come out, but we wanted to get an update in terms of where we are and how we're going to achieve the deadline of April 1st. So Commissioner Winters, I'm assuming we start with you.
Yes, thank you, Madam Chair. For the record, Chris Winters, Commissioner of the Department for Children and Families, and coincidentally, my first day in state government was April 1st of 1997, so a few years ago.
Been a ride ever since,
It
right?
has, it has. Thank you for the opportunity to give you an update on Raise the Age. Our next Raise the Age report is due at the end of the month, so that's been drafted and we're doing some revisions to it now. It's moving up the chain for approval. But we can give you a bit of a sneak preview of what's in there today. And I have with me Deputy Commissioner Erica Radke and our Director of Adolescent Services, Tyler Allen, here available to answer any questions that you might have. As you might suspect, we are still in the position of saying we have a lot of concerns about implementation on April 1st. Generally speaking, it's workforce concerns, it's facility concerns, it's IT concerns, and a number of other things that are listed in the report, many of the factors that the legislature requires us to report on every other month since you were last in session. And we can speak further to some of those. I will say we have made a little bit of progress in that we have the Red Clover temporary secure stabilization facility open in Middlesex. And so we have 2 youths in there residing there now. And so that's a great relief to the system of care and progress and an improvement, something that we didn't have that opened in October. I think we took our first resident on October 22nd.
So Commissioner, there's 4 beds there, correct?
That's correct. It's 4 beds. I will say we are still awaiting some background checks for full capacity of the staff. So we have 2 beds available right now. We expect that to go to 3 beds any day now. And in December, it'll reach full capacity of 4 beds.
Is there still work being done down in Windham County with some beds down there, or is that fallen through?
That is correct. The Wyndham County Sheriffs, and I defer to Director Allen to talk a little bit in a little bit more specificity. I know the construction contract has been awarded. Construction is underway. In terms of a provider and an actual start date, I defer to Tyler on that.
Thank you, Commissioner. For the record, my name is Tyler Allen. I'm the Adolescent Services Director with the Family Services Division. And so as far as the update, the Commissioner is correct. Construction is already underway on that program. The lower level of the Wyndham Sheriff's Department is being renovated into a program which functionally will be a 2-bed program. Crisis stabilization program. It is a non-secure facility. So those doors, while there are delayed timer locks on the doors, just to provide for safety needs for residents, it is not a secure facility. So I want to make sure that folks are aware of that. And that we're anticipating construction to be resolved early in 2025, ideally January of 2025, I think at this point. We have a concurrent process right now where we're developing an RFP to identify a new provider. At one point, we had some providers who expressed interest. Since then, they have moved on to other projects. So we're going to, I think our intention at this point is to put out an RFP and see if there's anybody else, or if that initial provider might turn around and come back and still have an interest in developing some capacity in that program. Our goal is to have a program operational by early spring of 2025.
Great, thank you.
You're welcome.
So sorry I interrupted, Commissioner.
That's quite all right, Madam Chair. We do, I'll just reiterate what I've said before, and you've heard from me and from others who work at the Department for Children and Families, is that we want to be able to achieve that final implementation when we're in a position to do it well and make sure that we can be successful for our youth and for our staff. But we are still in a position where we have a workforce shortage. We have staff that are stretched to their limits in other ways because we don't have those secure facilities or high-end system of care beds. So they're doing alternative staffings. So we have significant concerns about implementation on April 1st. I think you'll also hear us this legislative session talk about what works with Raise the Age and the things that are not working, what things seem to work better with using the youthful offender statutes and model, and what things don't work there, and to see if there are some changes that we could make to fulfill some of the intent behind Raise the Age without doing the damage to our workforce and our care for the other youth who are in our custody and care by implementing a full Raise the Age on April 1st.
So you're going to be submitting proposed legislation for any of that kind of session?
I don't want to get out ahead of anything that might be in the works, but we definitely want to have that conversation. We've had some initial conversations with legislators about that, and we'll do that before the legislative session to give everybody a heads up on what we might be thinking, and we would look forward to some potential changes around Raise the Age and around youthful offender.
Would some of that be in your report that's due at the end of the month here?
It will not be, no.
It will not be, okay. Precise.
Sure.
Commissioner, I'm just wondering, because in my mind, they're connected, how things are progressing with the Virgin's program.
Yeah, thank you. So that's the longer term view of a permanent secure facility with both crisis stabilization and longer term treatment. And then we took to heart some of the comments we've received in previous Joint Justice Oversight Committee and other committee meetings to be a little more explicit in our preparation for 19-year-olds. And so we've had some additional design conversations. Tyler Allen, again, I'll defer here to Tyler and his work with the facilities stakeholder group and with the architects will say we're still very much in the design phase in Virgins. And we're also kind of put into a negotiation position with Virgins as they've made public the things that they'd like from the state in exchange for hosting a secure facility in Virgins. And I think, some of their offers are very reasonable. Some of them are perhaps not doable, and we're still going through the process of seeing what takes legislative action, what's something the governor can do, what's something the DCF can just say yes to, what involves the agency of administration. So how can we say yes or no to many of the things that they put on their opening set of negotiation and requests. So this is, we think, probably a ways out. We've still got design to do, and then we've got a permitting and zoning process, and then we've got the actual construction process. But I'll defer to Tyler at this point to talk a little bit about the design process and how that fits in with potential implementation of Raise the Age.
Thank you, Commissioner. So as the committee might remember, when we last talked, we had proposed a kind of two residential facilities within the campus served by a common educational administrative structure. And at that time, we had understood there was some feedback, that there were some limitations around the outdoor recreational space available, that there was some expressed interest in developing some vocational program capacity for residents in there. And so we were starting to work with that. But one of the things that came out of the last Joint Justice Oversight Committee that we participated in was the concern that 18 and 19-year-olds really couldn't easily be served within these two houses. One was a 8-bed crisis stabilization unit, one was a 6-bed longer-term treatment unit, and this would serve a population really for 12 and above, and that it would be inappropriate in many cases for a 19-year-old, for example, to be placed into the same treatment program as a 12 or 13-year-old, even if their juvenile justice standing was in similar capacity. I think we took that to heart. We have an understanding around, while they are in some ways within the same overarching developmental framework in terms of what types of services are offered, there is a big difference in that age group, and we do want to be sensitive to the needs of individuals in there. And so we took that question back to our design team. We created a third structure, a third residence in there that kind of mirrored a little bit what the crisis stabilization 8-bed facility would be. The difference being that this would be more dividable. It could turn into, it's kind of 2 4-bed clusters that can exist as one house, or can be divided up. If you're only using 4 beds or you have less capacity, you can just use half the house, so to speak. Or if you need to make a differentiation between a crisis stabilization program and a longer-term treatment program with an 18 and older population, you have the capacity to do that within one structure. So we kind of added that structure into the equation. As we're looking at a multiple house sort of thing, rather than have one larger edifice, which contained a gym and contained an administrative building and the dining function and the educational room, we divided those parts out a little bit. So you have the administration, which has a central intake, and then you have a separate the educational facility would be separate from them. We reorganized them on some site plans, and we've been playing with that design. And just this past week, just about a week ago, we met with a smaller work group that is focused on design elements specifically around these programs to start gathering feedback around how we're organizing that. The smaller work group is going to meet again in the next 2 weeks to look more deeply at the specifics, the floor plans, then the layouts of each of the houses as designed. Some really good feedback came out of those conversations, talking about when youth leave, one of the very relevant things, when youth leave one residence to go into another building, for example, what is going to be the practice of having to search and research youth as they move from place to place through there? Because obviously, if you are having to do searches on youth frequently throughout their days as a part of their stay in a program, none of that aligns with the kind of normalcy mentality that we're looking to really achieve with this therapeutic environment. So we're having to have really thoughtful conversations about the facility design's impact on the experience of a young person in the program. And it's a very useful group to have pulled together. We'll bring, of course, those recommendations and the feedback of that smaller group into the larger public facility stakeholder working group.
Okay, thank you very much. I appreciate that and appreciate you thinking about the feedback that we provided previously.
I know that this is what's called the design build, where there's a developer who's designing this and working with you folks. Are you also working with the Department of Buildings and General Services as well on this? Because they're involved with contracting out a little bit with all of this.
Yes, we're working very closely with BGS. With the transition in leadership, we're working to get the new commissioner up to speed. The two of us will be going to Virgins in a week or two to meet with the folks there and talk a little bit more about their concerns and their asks. But we do have regular meetings with the department, with BGS, in order to make sure that we're aligned on that. They are pretty much the drivers of the networking, of working with the drivers of the permitting process and the zoning process. They have been working with the city. I've taken more of an active role in that since the departure of the previous commissioner. But we do make sure we're in pretty regular touch with them.
And there's no town vote, there's no city vote on this one at all, is there?
The city is definitely contemplating a vote on town meeting day to help influence their decision on whether to support the project or not. You know, we have it would be a non-binding vote. We've kind of expressed our concern around that, but if that's the way they'd like to proceed, we certainly will honor that. And, you know, hopefully we'll have a good negotiation with them soon and get to a place where we can show that this is of positive benefit to the city of Virgins. No, that's not only good for the youth and for the purpose that it's serving, but also for employment and economic development. And there are some other things that we can hopefully do for Virgins that they'll see as a real positive in welcoming a facility like this into their city.
I know the drill. I've been through it. Hopefully everything will line up. Hopefully if they do have a vote at town meeting, will be a positive vote.
Thank you.
But I know what needs to go into it before you get there. And there
Correct.
may need to be some legislative action for that.
Absolutely. I know one of the things that they're interested in is the state-owned land for housing purposes, I believe.
Questions, other questions of the committee members? Anything before we finish up with this? Thank you, folks. Appreciate it.
Actually, can I make a quick?
Yeah.
So we're talking about a conversation of how to meet the goals of raise the age in a way that will get as many of the benefits as possible. But I just want to obviously emphasize that that conversation has to occur very early in the session if anything's going to change for the April 1st presumptive date of moving forward with this. So just wanted to make that clear.
Thank you. Thank you, Representative Lalonde. And you know, I guess what I would leave folks with is that, you know, we're thinking hard about how to meet the goals of raise the age, what works well and what doesn't. And when we look at this over what we've learned over the last multiple years before my time at DCF, the youth that we serve well and the ones that are successful have a network of people around them, and they have natural supports. They have their basic needs met. They're willing to engage in services. And one of the real challenges that we have is when a youth turns 18 or 19, they have more freedom of movement, more free will. They might not be in their home. They might not be in stable housing. They might not have those support networks, and DCF can't force them to engage in services. So those are the pieces that we're really looking at to make sure that they are successful, that DCF can actually handle the caseload, handle the kids that are coming their way. So we built this really great process for appropriate youth to avoid those collateral consequences of the criminal justice system, but we don't necessarily have a successful system that can support them. So those are the pieces that we're looking at in trying to create a workable proposal that allows the right kids to avoid those collateral consequences and allows us to be able to have the kind of the authority to support them. So those are the kinds of things that we'll talk about, and I'm really looking forward to having that conversation very early with the legislature in January, and appreciate your focus on it.
Anything else from folks? Again, thank you. I appreciate you coming in. I'm sure we'll schedule you for our December meeting so that we can go over the report.
Sounds good. Thank you, everyone.
Thank you.
Thank you.
Okay, committee, so we got one more thing. We got the new letter about the earn time. And then I just want to quickly just talk about our next meeting in December, December 7th. So Ben, it's you again.
Me again.
New draft, and we'll put it up on the screen so that folks who are in Zoom land can see it.
Log back on. You just turned out.
Uh-oh, you can't get on?
No, I'm on. It's just accessing the documents again is what's proving difficult. Okay.
There we go.
We did it.
Yeah.
Okay, so for the record, Ben Obrowski from the Office of Legislative Counsel. The changes all occurred in this last paragraph here. So it now reads that the committee's overarching recommendation is that the system be overhauled at a minimum or a new provider selected altogether to ensure that the victim notification system operates as intended in compliance with state law, and that users are able to customize their user experience to militate against re-traumatization. During the committee's examination, it discovered several issues with the department's victim notification system, including the efficacy of the system, who is responsible, and the problems with the user experience. As a result, it is recommended that your committee explore which entity or entities should be responsible for enrolling victims into the notification system, educating victims on its use, and notifying victims of an offender's early release. Further, your committee should consider these whether these responsibilities should be placed on one entity during the pretrial process and on another post adjudication. Specific entities to consider are the Department of State's Attorneys, the Judiciary, Center for Crime Victim Services, and the Department of Corrections. Indeed, these entities have formed an ad hoc working group to address many of the listed issues. This ad hoc working group should serve as a resource for your committees as you undertake this work in the upcoming session. And that's a signature on the next page.
So I'm wondering where it says notifying victims of an offender's early release, if there's other notifications in terms of testimony that we heard, wasn't necessarily that they were released, but that they may have absconded or violated certain conditions or something. Am I overthinking that?
No, it was that, and it was changes in earned time, it was changes in ed time, I guess it was more general.
Well, notifying victims of the offender's early release, that would be.
Maybe status.
Taking bail.
Making bail, there were certain, but not limited to.
Including or.
But not limited to.
How about just notifying victims of an offender's change in status?
Make more sense in early release, because early release is pretty specific.
Right, an offender is also the post adjudication. Some of these folks that they're talking about will be adjudication.
It's not defined here in the letter.
Okay.
But I can do inmate because it encompasses both.
Well, inmate encompasses those who are incarcerated, right?
Right.
Offender means someone who has been sentenced.
Sentence.
Inmate is incarcerated as a detainee, so. These are
But it
things
can
that-
include offenders as well. It's anyone
Right. But
incarcerated.
it's not just folks who are incarcerated, are we? Right.
We can say people who have committed a crime. No, they're accused of a crime. Or accused, or are accused, or charged, I don't know.
Alleged offenders.
There you go.
Alleged
Or-
offenders.
Although those who are actually incarcerated are no longer just alleged.
Right.
I know.
But by Isaac's definition or use of offender in this instance, which
Yeah.
again, is not defined, it's defined in statute, but not here. Offender is those who are sentenced.
Well, can it be offenders and alleged offenders?
How about just detainees and offenders changing status?
How about people under the criminal justice system?
Justice involved.
Justice involved.
Yeah, because the situation could be that an individual is cited into court for some crime that there is a victim, and that victim should be notified, presumably, if the person at arraignment is released on conditions, for instance. So I think we want to have it as broad as possible for the notification.
Justice involved individuals.
And I always have a bugaboo about a signature appearing by itself on a page.
Yeah, right.
It's not good.
Right.
The reason it's not good is because other things can be inserted in between that page.
Taken out.
Mm-hmm.
So we got to get rid of a sentence or two.
Or I'll just.
I'll
break this up.
just space it down. That's all right. The address at the top, we can space it down and I'll go over.
What I'll do, here we go.
I think that gets at what I was concerned about earlier.
It does.
I think that, yes, I think that it does. Thank you.
So where is the language that you changed there
It is,
as a result? And notifying victims of a justice involved individuals change in status. Does that work for folks? Again, for folks on Zoom, I can't see you except for one person, so anyone can weigh in.
Works for me.
Works for me.
Else? So committee, okay, that I sign this letter, send it off to our respective committees?
Yep.
Okay. Then I'll sign the other letter too.
Yes.
Yeah. Okay, before I leave today. So yeah, we still got you, Ben.
still got me.
Overview of committee mandates and reports due, which will help us figure out our December meeting, because our December meeting is on the 17th.
So just to quickly review, the committee has accomplished its mandates as far as work that it needs to produce, which were the pretrial supervision recommendations, earn time recommendations, and hearing those raise the age implementation progress reports, which have been submitted by DCF, throughout the summer and fall. There are a series of reports due to this committee. One is the Coordinated Justice Reform Advisory Council report, which I believe has been posted. This is a result. This came out of what's it, S14, which is Act 40 of 2 years ago. And this essentially just directs the use of no more than $900,000 from the DOC's Justice Reinvestment line item for use for those purposes, essentially. So it's a series of people that are all kind of stakeholders in the criminal justice process that get together to discuss the proper and prudent uses of that money. It was envisioned to be the next step to take over from justice reinvestment to sort of manage any justice reforms that are needed in the state. However, if you read the report, they recommend that they be dissolved. So that might be something that you may want to consider going into the legislative session. What else is there? There is the criminal justice related investment and trends report, which you heard Rachel Jolly mention. I'm really glad that she mentioned it because I was not aware it had been submitted yet. And this is a big report from 2 years ago that was mandated that's going to essentially give an overview of whether the investments that the state has made through justice reinvestment and other investments in the criminal justice system have been successful or not. So it's essentially showing the trends that are related to those investments to help better inform all of you whether it's been worth it or more work needs to be done and things like that. So it talks about bail rates, recidivism rates, returns to incarceration after release, literally everything you could think of. So that has been, I believe, posted by Megan, and it has a series of links within the report that really breaks out all of this information. So might be good morning reading.
That out to us, you have, my mind's been elsewhere.
And it's on the reports and resources section of the website. It's different than where you access documents.
So can
Martin?
I ask a question and also weigh in on that particular? So just to confirm that's the work that the crime research group primarily headed up, right? So
Yes.
I've talked to Monica Weaver, and Her suggestion was coming in front of this committee and kind of giving a higher level overview because we could really get lost in the details of that report, is my understanding. So I would recommend that we do that and have
So why
her
don't-
in to give us that high level overview of the report and
Right.
and how to work the report essentially.
Because the report, we have it listed from Monica Weber
Mhm.
on our email, so if we could see if we can have Monica come in at our December meeting. Give us a quick walkthrough. Won't be quick.
And then the final report that was due on November 15th that I have not seen is from the Vermont Sentencing Commission, and this came out of H645 last year, to essentially assess what to do with pre-charge diversion records and their retention. It was due on the 15th. I haven't seen it, but maybe others have. But that was related to our previous discussion about record retention, especially, Tim, Leaders Dumont highlighted the prosecutors need to retain certain information, but it was to get the Sentencing Commission's view of what appropriate record retention would look like if there was sort of a set period of time before they could be deleted, if they needed to be retained in perpetuity, or some different version of that.
But we
I'm
don't
pretty
need,
sure that
go ahead,
the
Mark.
judge, I'm pretty sure that has been submitted, that report from
we-
Judge Zone.
All right, so we don't need to schedule testimony.
Wasn't that one? And then the one that you sent me was about sexual assault definitions.
So what we need to hear from reports for our next meeting is the Raise the Age report, the Justice Reform Advisory Committee in terms of the JR $2 and the recommendations. Should be aware of that, shouldn't we?
Yeah.
Because that's gonna come up in a probes. And then for Monica Weber, the investments in JR2, how successful have they been? Any other reports? That's it, right? So we did also put out a challenge to the VSEA and DOC about coming back to us in December with brainstorming thoughts on how to recruit and retain staff. I know that VSEA submitted an email to me a day or two ago, and I have submitted that to Megan. Take a look. Then DOC hopefully will be submitting something, so we'll spend some time at our next meeting for that.
Do you want me to post that? The attachment that they.
Why don't you send it out to committee members and wait to post it until we put together the agenda?
Okay.
And I know VSEA has asked at our December meeting to also have the state's attorneys testify, but I'm not clear what that would be specifically, what that would be on. So I need to follow up on that. My mind has been a little consumed with something else. I don't know what, I'm gonna deal with it after. Deal with it next week. And I know that Ginny was talking about us submitting a report, things in our report. We don't generally submit reports anymore, so I don't know how to best deal with that.
Well, I think I answered that question saying that the letter of the earned time recommendations served as
There's one,
the
but,
report for that, but I don't know what she specifically.
well, she's concerned with some diva issues. And the overall cost of placing if we did away with the well path contract, what would the real cost of that be on the state level? And what does that do with Viva?
All right, well, they told us that already.
Yeah.
The Department of Corrections gave us an
I
estimate
know,
about
but
that.
she wants to do a little deeper digging,
Right.
dive into that.
I think maybe she'll have to do that in her committee. I mean, we only have one meeting
I know.
left.
Yeah, so what does she exactly envision,
I don't. She just left notes for that.
So one of the questions that I had is sort of related. I didn't know where she was going with that necessarily was, we have, looking back at the, committee work document that you gave us back in July. And, we should probably look and make sure that we've at least addressed things that we've been charged with.
So one thing that Ben and Megan and Ginny and I do, we do get together on Zoom to structure our agenda for next meeting. And that's one thing we can look at. It's what you put together at our first meeting, but you're indicating we've done everything.
Yeah, the only things that were mandated for the committee to do was the earned time expansion review and the pretrial supervision, which you've done. Everything else is sort of, it's not required, it's just whatever is the hot topic.
Yeah, whatever came up.
Yeah. So for instance, the DOC VSEA issues, that was something that has been brewing, I guess. Pretrial diversion was something that, new program, but no mandate to review it.
Raise the age, same.
Same with raise the age. I mean, those were just, the requirement was that DCF submit bi-monthly reports, to this committee, which it's done and it's testified to. And then that record retention report that I haven't seen yet, which may be out there. And then, the investments and trends report, which we just received. And then the Coordinated Justice Reform Advisory Council recommendations for the $900,000, which we have. So.
Well, I mean, I feel like we should, for the, I don't know, maybe other people feel differently, but for things where we're specifically, listed as a recipient of a specific report, it feels like we should at least review that report. If we have it. I mean, I don't know what things that, are, when they're saying submit them to us, I'm presuming that even though the statute doesn't specifically say that we take any action on it, I mean, if there's something that we can recommend back to the committees of jurisdiction, then, we could.
Well, and typically.
Or something.
So for instance, the raise your age reports were not only submitted to this committee, but also to the judiciary committees, corrections and institutions, human services, and health and welfare. So we're typically one of many.
Yeah.
But yeah.
Well, the ones that we have, we're going to hear, but we're going to hear from Raise the Age. We should hear from the Justice Reinvestment too, that whole thing about the 900,000. And then we've got Monica Weaver coming in on the investments and how successful were they. The only one we haven't thought of scheduling is the Sentencing Commission report.
Well, from what I remember, Judge Zone is the chair of the Coordinated Justice Reform Council. So I don't know if you want to tap in to come to testify next
Do
month.
we want to hear testimony about the Sentencing Commission piece?
Well, that,
No.
I mean,
No?
I'd say whatever Nader and Martin think, that's what I'll go with.
Yeah.
I don't know.
I mean, it has to do with expungement and sealing and the like. And I know that Nader really wants to hear about that, but we on the House side don't want to hear that unless it's associated with a Senate bill coming over after crossover, because we spent a lot of time earlier this year. I'm fine not to hear from the Sentencing Commission on sealing expungement.
Are you fine with not hearing it, Nader?
I was going to say, I anticipate Senate Judiciary will be hearing a lot regarding that in the near future. So I'd be fine not hearing from them for now.
We'll punt it over to
because
you. Is
I'll
that
certainly
fine?
be hearing them soon.
So, thank you. Topper,
Are we gonna do anything more at all than what we've already done? With the VSEA, the complaints about that, the shift that those, the hours that they worked?
So what we've done, Topper, at our last meeting in October,
Yeah,
I challenged both VSCA and DOC separately to
right,
go brainstorm on how we can deal with recruitment and retention. And the goal is to really deal with those issues that will help in that shift, those shift changes.
yeah.
Work-
So we're
working
just gonna
shift.
leave it, let them,
They're due to come back in December
yeah,
with their ideas.
right, okay,
And in the letter that was sent, it said to do that, and then it said, if you don't do it, the committee may recommend to the standing committees of jurisdiction to consider policy decisions that may be unsatisfactory to DOC, VSEA, or both.
Yeah.
So.
okay.
So they can give us their Christmas presents. Anything else before we finish up for today? Right on time. Anything else? Great. Thank you all. Have a nice Thanksgiving. Our next meeting is December 17th, and let's hope there's not a snowstorm that day.